Hi, I'm Amber Cohen with Her Legal Lens. So today, day two, Commonwealth v. Kelsey Fitzsimmons. Goodness, it's been a long day. It was the defense attorney Bradel's opportunity to cross-examine Officer Noonan. So before the jury even heard a word of testimony, the defense made a move that set the tone for the entire session. Attorney Bradel asked the judge for permission to cross-examine Noonan, the officer who shot Kelsey Fitzsimmons, on three specific issues related to the North Andover Police Department treatment of Officer Noonan. Now, most of this argument was done at sidebar, so we did not get to see it. However, ultimately, Officer Noonan was excluded from the stand, asked to leave the courtroom, and then the judge did allow some public hearing. The reason why the judge didn't want to have too much of a public hearing is because he doesn't want to tarnish the officer's reputation unnecessarily, right? So obviously every good defense attorney wants to try to harm the credibility of the witness, but here you have an officer and without being too pressure tested on the allegations that defense attorney was raising, Attorney Bradel was raising, but the judge ultimately did allow him to testify to three issues. One is that the department gave Noonan a series of breaks that no other ordinary officer would be allowed. And so those breaks really amount to rewards, and that is basically what Attorney Bradel is arguing as to his cooperation and why his testimony is so entrenched. So let's start with, I'm going to try something new, and here we go. We're going to just go in and look at some testimony.
Please. Thank you. Good morning, sir. Good morning. Before we get into the case, I'm looking at your glasses. Are those glasses AI recording type glasses?
No.
Okay, so you're not recording anything right
Absolutely not.
By the way, I thought this was so interesting. This is where we're at. We're looking at glasses.
Let's go to June 30th at Kelsey Fitzsimmons' house. What time did you get there?
I think right around 6 or 5:30, 6 o'clock.
The upshot of that visit was that when you got there, you didn't secure the firearms, did you?
No, we didn't.
And you brought the guy getting the restraining order to the person he claims he's in fear of, correct?
I wasn't aware that Justin was en route. That was Lieutenant Daly when he made arrangements with
I'm just going to pause it there, because if that is true, if the Lieutenant Daly did not make the other officers aware that Justin Alian was on his way to the property, that would be concerning to me, because obviously, as we talked about yesterday, when you have someone coming to the home who is, this is high emotion, it would seem proper to advise the other officers that he was in fact coming to the house.
Justin.
So you're saying that was, sorry, finish your answer.
Justin Allen.
That was your, that was not your part of this incident?
No, it wasn't.
And you're saying that oh, sorry, excuse me one minute.
We're just going to skip past some of that.
Mr. Prater, can you hold on 1 second?
Sure.
I want the jury box to be empty. So
I should have had this queued up just a little bit more. Here we go.
besides, show a witness what they're referring to when they're trying to.
I will, Your Honor.
Thank you.
I want to ask you some questions about your relationship with Kelsey.
Sure.
You said that you didn't know her well.
That's correct.
And you said that she was on maternity leave most of the time. Is that right?
Yeah, that's correct.
And you also said that you got along well with her, right?
For the time, I think we went to 1 or 2 calls together. Other than that, I worked a completely different shift. So we got along when we went to calls, yes.
Did you get along well with her or not?
Yeah.
And did you think well of her?
I really didn't have an opinion. I didn't have a chance to really get to know her.
Well, do you know Maureen Teresi, your neighbor?
Okay, this is where
Teresi.
Attorney Bradel.
You gave her your opinion of Kelsey, didn't you?
I don't remember.
You called her a whack job, didn't you?
I don't recall.
I'm sorry, Mr. Bradel, I missed the question. Can you state
Sure.
that again?
So
That's the thing. You always have to be able to say that question again, because sometimes a juror or someone can't hear it, and you definitely want to be able to restate it. Here, it's a pretty big piece. He's basically insinuating to Officer Noonan that, you know, you've gone around to your neighbors talking about Kelsey in a negative way, calling her a whack job, and you know, he's like, I don't recall, which is a standard answer when they don't want to answer. Short story. So, and, you know, the judge isn't a potted plant. I'm sure he's picking that up.
him if you knew Miss Maureen Teresi, his neighbor,
Okay.
and I said that he gave his opinion of Kelsey to his neighbor, and then he called her a whack job, and then you can answer again, sir. What was your answer?
I don't recall.
You don't recall?
I don't.
Is it possible you called her a whack job to your neighbor?
It's possible.
So that's what you really think about Kelsey, isn't it? That she's a whack
I mean, he
job?
acknowledges
tried
it's
to kill me.
possible.
And at the time, you went in there loaded for bear, didn't you?
No.
Well, let's see. You told the state police that the job was to section her, didn't you?
It was spoken about that if she reacts badly during the restraining order, she may have to get sectioned.
Well, you
Now, here is where oftentimes witnesses get themselves in trouble. Attorney Bradel just said you went in loaded to bear, right? In other words, you had a mission. Your mission was you're going to serve the papers, and then you were going to section her. And all he had to do was to say yes. That is what the lieutenant ordered. That's what we were going to do. Her mother was coming over. There was a plan. She was in a mental health crisis. However, he did not want to admit that. And once you don't admit that, once you can't acknowledge what happens, because you want to commit to a different path of a story, this defense attorney in particular, he's going to make you say it.
so you said that you had pre-planned that you were going to section her.
It wasn't
The job was to
pre-planned.
section her, isn't that what you said?
No, that's inaccurate.
So-
Hold on one second. Let me just go through some ground rules. You need to wait until the question is complete, because we can't have two folks talking over one another.
Yes, sir.
All right. Thanks very much. Go ahead, Mr. Bradel.
And also, you raised quite a lot of concerns about where Kelsey parked her car, correct?
Yes.
And you suggested at one point that you could box her in and take her into custody with respect to the car, right?
Yes.
So you were thinking that she was going to need to be sectioned, that she was a whack job, and that she needed to be boxed in and placed into custody, right? I'm asking what state of mind you're in.
Has testified that he thought she was a whack job before he went with her.
Overruled.
Those are all things that were in your mindset, weren't they?
No.
Well, you said them, right?
No, that's inaccurate.
Sectioning her,
It was brought up by my lieutenant that she may have to be sectioned
and you told the state police that part of the job was to section her.
if she were to be sectioned.
You didn't say that part to the state police, did you?
I don't recall.
Okay, well, we'll go over all this, don't worry.
Okay.
And so, with respect to the car, you testified in such a manner that you're suggesting that there was some suspicion attached to that, right?
Can you rephrase?
Yeah, you're suspicious of the fact that she parked the car 150 yards away, you said.
Yes.
So, your mindset is that she's evading something or she's up to something?
Well, in my training and experience, the distance of where she parked her car from her house and having a baby, and also her behavior in the past where her car was always parked in the driveway,
So you didn't know her very well.
I knew where she lived, and I patrol the town, so I have to drive by her house.
So she parked.
That makes sense to me, right? I mean, North Andover, not a huge place, I don't think. And he's patrol, so he sees that her car is there, which is fine. But to me, my first thought is maybe she parked away from her driveway because she didn't want Justin to know if she was home. Maybe she didn't want people to know she was home. Not that she was trying to get away or evade, but I don't know if that's that weird if you're fighting with your significant other and you don't want them to know you're home. I think that's actually kind of something that a lot of people do, but maybe that's just me.
The school next to her house.
Yes.
What are you thinking she's going to do?
I don't know. I don't know what her mindset was.
So you're speculating about any suspicion that's attached to that parking job, right?
I was just suspicious about that.
So she's in the house. You
Yes.
know she's in the house.
No, I don't.
You go to the house. You knock on the door. Daly knocks on the door. She comes out like a regular mom.
Yes.
Holding the baby, wearing sweats, hair's probably in a ponytail, opens the door,
Yes.
right? So at that point, do you let go of your suspicions about where she parked the car?
I was still curious as to why she parked her car over 150 yards away.
Well, you're looking at it through your own lens as an investigator. Isn't it possible that there's 100 other possibilities in her life that maybe she parked there for some other reason?
Yes.
Could be. I don't know. Again, I don't know what her mindset was.
So you go in there, and you are the only officer who has tactical gloves on when you go in there, correct?
They're neoprene gloves. Yes.
So you're
In the video that we saw yesterday of when the officers go into the home, he has the neoprene black gloves. And ultimately, I think that's because they probably had tasked him with picking up the firearms. And so this testimony is going to go into that. But, Noonan tries to walk back saying that the sectioning was speculative, just something Lieutenant Daly had mentioned as a possible outcome. But the defense's point was really already made, that if the officers went into that house with a plan for an involuntary commitment, that changes the entire picture and the intent of going into that home. They weren't just serving paperwork, they were prepared for confrontation. They expected one. And so what that means is that he had a heightened level of stress already going into that home.
for anything, right?
It's past practice with me after working in Lawrence for so long. I tend to glove up for sanitary reasons. I knew we were going to have to handle her firearms, so I didn't want to get any of my prints or anything on them.
But you said you took them off fairly quickly when you got in there.
Yes.
And at what point did you take them off?
Right before she handed me the baby.
That makes sense to me, by the way.
So you hadn't yet touched the firearms and you took them off. So that plan about not getting your prints on the firearms didn't pan out, did it?
I didn't want to hold the baby with those gloves.
He probably wasn't expecting to have Kelsey hand him the baby. I mean, she handed him the baby. And so he took off the gloves so that he could receive the baby. I mean, I think there was a lot of things that went wrong this day.
While we're talking about holding the baby, it's fair to say that Kelsey Fitzsimmons, with 3 cops standing there, had her baby, and she's the one that chose to give it to you. Isn't
Yes.
that right? You didn't ask for it. Daly didn't order her to give it to you. she, with whatever her mindset was, chose you to take her baby. Isn't that right?
That's correct.
And
That's a good
she
point
chose
for
you
defense.
to take a bottle and feed her baby, right?
That's correct.
And then this is 5 minutes before you say she tries to murder you, right?
That's correct.
Now, you said that you felt that the baby couldn't be comfortable because you had your vest on. So it wasn't comfortable and you wanted to give the baby up to someone else, right?
That's correct.
Fair statement?
Yes.
Okay. Well, that's not what you said prior, is it?
Well, I like to have my hands free as well. I don't like my hands tied up.
That's what you said the last time, right? That when you spoke with the state police, that you didn't like having anything in your hands, and it was really a tactical reason why you gave the baby up, right?
No, it wasn't a tactical. I just didn't want to be holding the baby.
Isn't it tactical that you want to have your hands free to deal with anything you have to deal with at this?
I want to have my hands free on every call.
What's
that I
wrong
go
with
to.
the word tactical? Why isn't that tactical?
Can you rephrase that?
What's wrong with the word tactical?
There's nothing wrong with that.
So why doesn't it apply? Because I said it?
I'm sure it could apply.
Objection, argument.
I'll strike that, Your Honor. Why doesn't it apply?
I'm sure it could apply. Sure.
So for tactical reasons,
Here, Attorney Bradel is trying to get control of this witness, right? So he's saying this was a tactical decision, and he's like, no, it's not. And so Attorney Bradel is really bringing in this word and saying, what's the problem with this word? And then ultimately, he said, is it because I said it? So the objection is sustained because it's argumentative. You're not allowed to argue with the witness. But he's making the point, he's trying to get the officer to sort of get in line and answer his questions.
you gave up the baby. But that's not what you said here at this trial, is it?
I don't recall what you. Can you rephrase that?
Well, here at the trial, you said that the baby couldn't have been comfortable and you wanted to give the baby off, right?
Yeah, that's correct.
And you didn't say anything about wanting to keep your hands free for tactical reasons, right?
It wasn't asked.
You were asked what happened repeatedly, and you had every opportunity to talk about it, didn't you?
Sure.
And you left it out.
Not on purpose.
We'll see.
There's a
Comment like that isn't helpful, please.
Sorry, Your Honor, motion is straight.
a little comment under his breath, and he says, we'll see. The judge heard it and admonishes the comment, and then there is a moment of levity where he moves to strike his own comment.
You're moving to strike your own comment?
I am.
It's allowed. And that's very forthright of you.
So, you know, when you're in court and you are sort of battling it out on cross-exam with a witness, especially someone like Officer Noonan, right? He's the victim in this case. But the challenge is really to what his perception was, what happened that day, the credibility of his testimony. So he is really, making Officer Noonan work on the stand. And that can, when you're in a groove and cross-exam, that can take a lot of energy. And sometimes, comments do slip out. The judge did allow him to acknowledge it, and they're moving on. And we're going to move on too. So the next part that I want to get to is they go through.
Kelsey went into her bedroom after being in the baby's room, correct?
Yes.
This is right before the shooting.
You don't go in the room, right?
No, I stayed at the very top of the stairs, right before the door frame.
All right, so it's fair to say you're on the landing, the top of the stairs, looking into the room.
That's correct.
And the room's got a lot of furniture in it, a lot of things everywhere, right?
Yes.
So you say that Kelsey has a change in her demeanor, right?
Yes.
She starts to shake and get upset, shaking uncontrollably, you said, right?
Yes.
I have some water too, actually. I'm losing my voice.
Then she lunges.
Yes.
She's on her knees.
She was I believe on her right knee.
You said that she pushed off her left leg and lunged, right?
Yes.
And at the time, you were 3 feet away from her,
Yes.
maybe less.
Maybe.
So can we agree that's arm's length?
She was a little further away than arm's length, I would say.
So arm's length if you reach over me. How about that?
Yes.
And your testimony is that she lunges over and obtains a gun,
Yes.
right? And she assumes a certain stance.
Can you elaborate?
Well, you were there. What stance did she assume?
She pointed a gun at my face and pulled the trigger.
And yesterday, when you were being questioned, you assumed a two-handed stance to show that, didn't you?
That's correct.
And what do you call that kind of a stance?
I don't know.
Like a modified Weaver stance?
Yes.
So she assumes a modified Weaver stance. Can you stand up and a modified Weaver stance? Your Honor. That's just what it's called.
Okay.
Can you demonstrate to us what a modified Weaver stance looks like?
Do you want me to stand up and show you? Sure.
So are you asking him just in general?
Just to
or-
show the stance in general first, yes, Judge, thank you.
So she grabs it, pulls the trigger.
Yeah, that's not, I don't think that's what he was asking you, but.
So just what's the modified Weaver stance? What is it?
Here.
And what, can you describe it? What are you doing when you do a modified Weaver stance?
Strong side. Strong side. All right. So if I'm righty, this is my strong side. That's going to grab the pistol, and I use my support hand to support the weapon.
Are you righty?
I'm sorry?
Are you righty?
I am.
You can have a seat, thank you.
Thanks.
And you're saying that Ms. Fitzsimmons had the gun in that kind of a stance?
Yes.
And how far was the gun away from your face?
It was right outside of arm's length.
So she's 3 feet away. She assumes the modified Weaver stance, so she's probably another foot or two towards you, right?
She stepped to the left. I don't know if she stepped towards me.
Well, your testimony was that she immediately lifted the gun to you and
Yes.
pulled the trigger and tried to shoot you right in the face.
Yes.
So the gun didn't go off,
No.
and there she is with the gun there. The guns didn't go off, and you're within feet of her and the gun that didn't go off, right?
That's correct.
And you didn't just grab her, did you?
No, I was in complete shock. And then she started backpedaling immediately and trying to tap and rack that weapon.
Right. So your testimony is that Kelsey goes from a wounded bird shaking uncontrollably to a female movie action hero, doesn't she?
Those aren't my words.
That's your description of what happened, isn't it?
I didn't describe that either. In
So
those words.
she gets the gun. She tries to murder you in the face.
Yes.
5 minutes after she has you feed her baby.
Yes.
She pulls the trigger, nothing happens.
Yes. It went click.
She stands up, right?
She was already standing.
So as she's standing, she shoots you she tries to shoot you in the face.
Yes. And then she started to backpedal.
So first she backpedals, then she sidesteps, she tap racks again, right?
Yes.
So in all this time, this is like the longest tap rack in history, isn't it?
It's 4 seconds.
So she gets up, she sidestep first or backpedal first?
Backpedals.
So she backpedals first.
And then
How many
sidestep.
steps?
I would say maybe 4 or 5, and then maybe another 3, 4, 5 to her left, which is my right.
So she goes into action. She tapping the magazine and then racking the gun while she's moving around.
Yes, she's well-trained police officer
And so are you,
Who's a
sir.
whack job.
who tried to kill me.
So, let's get the order straight.
He did try to get that in several times, that he wanted it known that the judge heard that she tried to kill him. A response to a question that was not before him, notably.
You said that she backpedals first.
Yes, after she pulled the trigger.
And nothing happens.
Yes,
And then she taps the magazine
yes.
and then racks the slide.
I believe her hand slipped off. That's when she went and I was giving her commands, don't do it. And she re-racked and started to bring her right arm up.
And then she does it again, right?
Yes,
And you actually have no idea whether she successfully racked it the first time or successfully racked it the second time, correct?
that's correct.
You don't know what happened.
No, I don't.
And so it takes a few seconds to take 4 or 5 or whatever steps back towards the air conditioner, right?
From beginning to end, once she pulled the gun on me and pulled the trigger, and by the time I shot her, it was right around 4 seconds total, if not 3.5. It was very fast.
So she goes from shaking uncontrollably, sad about her situation, crying, to being pretty nimble.
She wasn't crying.
She walks, she backpedals, you said, right?
That's correct.
Then she sidesteps
Yes,
to the air conditioner. And you had a look of panic on your face at that time, didn't you?
no,
You were flustered, weren't you?
no.
Well,
He
you were
doesn't
in shock
like this
5
line of
minutes later, weren't
questioning.
you?
After the incident and my adrenaline dumped, yeah, I was in shock then.
So, at the time, getting back to the incident, Kelsey's by the air conditioner. She's backpedaled, she's sidestepped, she tapped, she racked, she tapped, she racked, and then you shoot her.
Yes,
And you shot 2 shots. Where are we on the rapid succession? Which one do you want to go with? Rapid succession, or you shot, gave commands, and shot again? Which is it?
I was giving commands and shooting at the same time.
Okay. Well, your prior testimony was that you shot, you pulled the trigger, gave commands, and you pulled the trigger again.
Yes,
So, was it that, or was it boom, boom, rapid succession?
it all happened in 4 seconds or less.
So, you're a very well-trained SWAT officer, yes?
Yes,
You're a firearms instructor.
no,
You're a patrol instructor, where you instruct
Was
other
a patrol-
officers on the job, right?
field training officer.
Field training officer.
Yes.
Thank you. And you've been doing this for 25 years,
No,
20 years.
right around there, yes.
Okay, so you've been doing this for 20 years. And one of your thought processes was that you wanted to give your training and experience back to the North Andover PD where you started, right?
Yes, and come back where I started.
And here, your first shot, you missed her from about 7 feet away.
I did. It was longer than 7 feet. It was at that point about 15 feet,
15 feet.
I would say.
Do you have any measurements on this?
No, but if you remove the bed and you were to walk diagonal from where I shot, it was probably around 15.
So the first shot you missed her and you hit the air conditioner. Is that right? Or
I didn't know where it went.
And the fact is that we have only one spent projectile in this case, right?
I'm sorry?
We only have one spent projectile in this case, correct?
I don't know what state police collected.
You weren't curious as to any of the paperwork or anything that happened in the case?
I believe they told me that there was one on the bed and one on the floor, I think. But I don't know where that one projectile comes from.
Did you know that there was one in the curtain next to the air conditioner?
No.
Have you looked at any photos from this at all?
Some, yes.
You didn't know that?
Nope.
Yeah, approach her.
Yes.
Just a photo.
Yes.
We're going to cruise along here because there's this long break. They're talking about the reputation evidence.
Do show that he was offered promises, inducements, or rewards for his testimony. Right? That's the theory. The first being, generally speaking, that he was not drug tested after the shooting. Is that what you're saying?
That's right, Your Honor.
I'm sorry?
It was a town policy. It's a town policy that after there's a serious incident, that the town would drug test the officers involved.
Okay. So number two, and I may not have these in the order that you raised them. Number two was that essentially you allege Officer Noonan missed a shift sometime after the shooting. Perhaps it was, let's say, medication related, generally speaking. And number three, that Mr. Noonan, strike that.
It's a good
Officer
thing that
Noonan
prosecutor
allegedly was
has
placed on
her.
administrative.
It's a good thing that prosecutor has her phone privacy screen on because she was just growing through and you can see it. And the judge is talking and that would be awkward.
But allowed to work details, and that you believe that to be in violation of some policy or CBA or
Yes, Your
something.
Honor. You're either a policeman who can work or you're a policeman who can't work, and you can't be performing details in uniform as a policeman.
Okay.
While you're out on critical incident leave because you can't work.
All right. So generally speaking, we did address some of this pre-trial in the sense that there was a Rule 17 motions, right, by the defense to get Officer Noonan's IAD files from Lawrence and North Andover PDs, which I believe Officer Noonan agreed, which is really unprecedented in my view, agreed to provide a waiver for him to get those. So, Mr. Bradel, so did you get the files that you were seeking, the IAD files?
Yes.
Okay. And so let's just go through each point. The first point about the alleged, well, let me say this, is I stand by what I said. The Commonwealth argues that these areas or these questions, strike that, that there's no view of the evidence that could show that any of these three things would be promises, inducements, or rewards under our rules, because whatever the North Andover Police Department did, they did as a product of their own administrative duties, and has nothing to do with the prosecution team, and there were no promises made in exchange for his testimony. So I'm sure that Ms. Moriarty could articulate that much better than I did, but let me try to cut to the chase. I agree with the Commonwealth, as I said before at the Rule 17 hearing, but I think arguably, and I want to hear you folks, that they could be asked, again, I need to drill down more, but they could be asked to show some kind of bias in the sense that North Andover Police, let's say, allegedly, and Officer Noonan are trying to curry favor with one another in lieu of their testimony, in lieu of his testimony here. Okay, let's just say arguably for a moment. But let's just go back now, Mr. Brado. What's your basis for saying that, for alleging that he wasn't drug tested and that there's some policy, or does the Commonwealth concede?
The Commonwealth concedes he wasn't drug tested, but that the Commonwealth position is that that's not a policy, that there's no violation of any policy because the collective bargaining unit policy trumps the general personnel policy of the city. And so, in that way, there's no promise or word. Can I put something else?
Yeah, please, please.
Right in my paper as I was
Sure.
reading it. I think, again, it's supposed to promises, rewards, or inducements. Officer Noonan provided grand jury testimony and a recorded interview to the Commonwealth.
We're going to forward this a little bit, and ultimately, the judge does allow Attorney Bradel to ask one question. So this is interesting.
Not drug tested by the
Oh, let me
town.
back it up just a little bit.
Both. Okay?
One question.
Okay. And do you need to speak with Officer Noonan about this before he returns to Commonwealth? Okay. All right. So he may resume the stand, Officer Noonan.
This will be our last little show here. I hate that I keep doing.
Thank you, Officer Noonan. And Mr. Breda, you may continue your cross-examination.
Thank you, Your Honor. Sir, I want to ask you some questions about some of the treatment you've gotten by the North Andover Police Department since this incident.
Sure.
Okay. Now, after this incident, immediately after this incident, you were not drug tested by the town or the police department, correct?
No.
All right, and you're aware that's a policy of the town?
That I don't know.
You don't know the town policy?
As far as the drug testing, no.
Now, you also
One question.
are on critical incident leave right now, or words to that effect, right?
Yes.
And that means that you're not able to perform the duties of a police officer for the time being, so you get put on leave, right?
Yes.
And yet, at the same time, you're being permitted to work as a police officer on paid details. Isn't that true?
Yes, that was our union.
Oh, it's just it's a yes or no question. Really.
Yes.
All right. And that is an accommodation that was made via a side. May I inquire, Your Honor? Or?
Not past one question.
Yeah, sustained. Next question.
That is something that is not ordinarily permitted, is it?
Sustained. No. You've gotten your answer. Okay, Mr.
Okay.
Bradel. Next question.
All right.
Judge Carpe plan. He said, I'm going to let you ask one question per subject. So we have drug testing, then we have whether or not he was working details, even though he was on critical incident leave, and the next is going to be...
Now, you also were absent without leave from a shift recently, correct?
Back in January. Yep.
And with respect to that, there was a reprimand letter issued to you, correct?
That's correct.
And at first, that wasn't going to issue, was it?
Let me just hear the question. What I was really expecting was one long leading question each, but that's all right. You're breaking it up. Let me just hear the question. Officer Noonan, please don't answer it
Yes,
until
sir.
I hear it.
So
Go ahead.
the question, Judge, is that reprimand letter that appeared in your file was originally not going to issue against you, was it?
That's the question?
Yes.
Okay, and you're going to live with the answer?
Yes.
All right, yes or no? If
I have
there-
no, I have no idea. I was just called in one day to sign it.
Okay,
So I have no idea if it was or it was not.
all right. So,
Okay, that's all I have then, Your Honor.
Okay, all right.
Thank you.
In that area, you're not done with Cross? Right, I'm assuming that you're.
In that area, right.
All right, so that was Officer Noonan. And I think, you get a good taste of it. Judge Karp has done a wonderful job staying very even-keeled, very fair to both sides. And that's really all you can always ask for with a judge, is being respectful, fair, listening to both sides of the arguments, and ultimately, being able to make decisions and relatively contemporaneous to the trial. So it was a really interesting morning with Officer Noonan. So next we had the ballistics detective from State Police, and Michael Bonasaro came in, 20-year veteran, hundreds of firearms examined and test fired. This is the type of witness the prosecutors love. He's calm, he's credentialed, he's methodical. Very credible witness. He walked into the courtroom. He talks about the semi-automatic handguns, the primer, the powder igniting, the projectile leaving the barrel, the slide cycles, the spent casings. He really taught the court a lot about the gun. Actually, I took one gun class. Actually, that's where Kelly and I met. We met at a gun class, and this what it felt like a little bit. They give you this sort of preview of how the gun works and what happens when you shoot the gun, and et cetera, et cetera. Anyway, so he explained head stamps, the engravings that occur when the cartridge leaves the barrel, the identity and manufacturer of the caliber within the gun. And he explains what it means for a gun to be in battery versus not. And so the judge even allowed a dry fire demonstration in the courtroom. So he put on his gloves, he picked up the gun, he obviously checked the chamber, he checked to make sure there were no bullets anywhere in the gun. He checked that, he loaded it. Oh gosh, now I'm not even remembering what he did. Anyway, he pulled it back, shot it twice. He showed in essence what would have happened on a misfire with Kelsey, if that in fact is what happened. So Bonacero's team responded to the scene the day of the shooting. He was there, he thinks about an hour. He was driving from another town. And so they documented the bedroom, they inventoried the weapons, they collected all the evidence. They also were able to recover 2 spent shell casings and 1 spent projectile, all from the bedroom. But they also recovered and test-fired 3 Glock firearms, Noonan's duty weapon, another officer's weapon, and a 3rd firearm recovered from the safe at the scene. The results were definitive, and microscopic ballistic analysis, Bonasaro confirmed that both shell casings came from Officer Noonan's gun, which we knew because Officer Noonan said that. So we have no reason to deny that he shot the gun. We know he did that. The 2 other firearms were excluded, so all of the head stamps matched, and I think they're called a Hornady 9mm across the board. So therefore, they were considered Officer Noonan's bullets and casings. All 3 guns were tested and functioned normal. What's interesting about Detective Bonacero is that there was a live cartridge recovered at the scene, one that hadn't been fired. Bonacero explained that no forensic analysis was performed on this, and because no one requested it. And because the science of matching an unfired round to a specific weapon is unreliable, unless the cartridge has actually been cycled through the gun. So that gap, the defense was able to exploit because the prosecution's narrative is that Kelsey's gun misfired. So if it misfired, there should be evidence of cartridge that the cartridge was in the chamber and stuck, but failed to discharge. However, forensics was not able to confirm that. So I think that's helpful for the defense. There was also a brief change of custody discussion. Basically, Bonacero acknowledged that when he showed up, he was given information from North Andover Police Department about what happened on the scene with that gun. And basically, what Attorney Bradel was able to get from him was that that gun had been passed from officer to officer to officer, and really no way to tell. So in that hour, he doesn't dispute that. Officer Bonacero doesn't, or Detective Lieutenant Bonacero does not dispute that. So he was a good witness. And all right, so then we have the testimony of Officer Houston, who really gave some emotional testimony. He is one of the 3 officers that entered the home to serve Kelsey Fitzsimmons with that restraining order. He knew Kelsey professionally. He had attended her wedding. They had had some social contact. This was not a stranger on stranger passing papers. They were friends. It was very clear that he was affected by this day. He was able to paint a detailed picture of those minutes right before the shooting, life-changing shooting. The officers arrived, entered the home. Kelsey was surprised. She did not even know they were going there. She didn't even know they were there. Because as you recall, Lieutenant Daly had said they parked around the corner so that she wouldn't know they were there, and then they walked up to the home. But Houston noticed something, that there were empty gun cases visible on the couches. So that detail did matter. They did stay vigilant. So it's interesting that they did seem to have that piece of knowledge. Houston put that into perspective for everyone. What followed after that was how he describes period of controlled chaos. Kelsey was packing the bags for Caden because Justin was on his way to pick up the baby. And at one point, Kelsey asked Houston to hold the baby. She suggested he take the baby for a walk. Houston read that as a possible attempt to separate him from the group, to get one officer out of the picture, but he stayed. He refused that and did stay. Kelsey's mom arrived at the home. Baby was handed to her. The officers were able to then accompany Kelsey upstairs, and that's when Officer Houston and Officer Noonan go upstairs where the shooting then occurs. He does get to testify to say that he heard Noonan shout Kelsey's name and then 2 gunshots in quick succession. Houston drew his sidearm, he radioed for the medics, and then he reached the bedroom. Ultimately, he saw Kelsey on the ground and Officer Noonan on the ground tending to Kelsey. Lieutenant Daly also was tending to Kelsey. Noonan was standing low and ready, weapon drawn, but pointed to the ground. So there was a detail that did stay with me, that was that, Kelsey was alive, she was alert, and what he said over and over again, and that what she said was that she was sorry, and she was sorry. And she never said she tried to kill herself. She never said she tried to shoot Noonan. She just said she was sorry. The ambiguity is at the heart of the case. Is she sorry because she tried to kill herself? Is she sorry because she wanted to die? Is she sorry because she pointed the gun at Officer Noonan? The ambiguity is significant. The prosecution says obviously she aimed a loaded weapon at Officer Noonan. You heard Officer Noonan say she tried to murder me, whereas the defense says evidence does not support that. The narrative doesn't support that. There's no motive for her to try to kill Officer Noonan. And Kelsey's own words in the immediate aftermath really don't resolve that conflict either way. So it'll depend on how the judge reads that. There was a battle about Officer Houston's testimony, hearsay evidence, whether or not he was able to say a statement that Officer Noonan made after the shooting, which was that Kelsey, she pointed a gun at me, pulled the trigger, and racked the slide. So that is something that the prosecution wanted Officer Houston to testify to. Big objections from defense. Ultimately, they had several back and forths, legal battle, and Judge Karp did allow the prosecution, Officer Houston, to testify to that statement that Officer Noonan made, which is that she pointed the gun at me, pulled the trigger, and racked the slide. But not for the truth, but for state of mind evidence. So obviously, the real argument here coming from the defense is that he has every reason to lie about what happened right after if he had made a mistake. And so this statement should not come in because it's not a credible statement. But the judge said, I'm going to let it in under excited utterance for state of mind evidence. And so that did happen, but he made it very clear it was not coming in for its truth. Lastly, the next evidence was one of Kelsey's friends. Now, Michelle Mitchell, she's a corrections officer and she knows Kelsey. In fact, I think she was a bridesmaid or was going to be a bridesmaid. I'm not 100% sure. I did not hear whether or not she was going to be in the anticipated wedding but either way, she had a phone call with Kelsey earlier in the day on the 30th, and Kelsey was driving, she was crying, baby was in the car, she was upset, and she told Kelsey told Michelle that that she needed Justin. And so she pulled over to feed the baby. Michelle said that she drove around North Andover trying to find her, but she wasn't able to find her. I guess she was that concerned. She wanted to make sure she was okay. And then later that day, she was over at Justin's friend Hunter's house. It was that they were having a conversation. Justin made the decision at that day to go file the 209A restraining order. So defense asked something about whether or not this was because there was a drinking party and he just went and got this, and Michelle shut that down. But at the end of the day, I'm not really sure what Michelle offered there for the prosecution, except to show Kelsey's state of mind, which is that she was upset, she was crying, she was erratic, and there was a little bit of back and forth. Attorney Bradel said, Justin was meeting her, and Michelle was like, are you saying he's needing her? And then finally, Attorney Bradel said, meeting her, and, they were not hearing each other. So either way, Michelle got off the stand, and that was it. There is a request by defense to go do a view if the judge wants to see it and thinks he needs it to assess the evidence. So it looks like this is sort of a big deal. Normally with a jury, a view is typically scheduled when you have a murder trial. The jury loads up in a bus, state police, escort, you got local PD to secure the scene, court officers for the judge, clerks, attorneys, defendant. It's a very big deal to do a view, typically done by motion, and then the judge considers it and determines, yes, let's go see the view, especially when someone dies. However, here, the defense thought it would be helpful to really evaluate how close in space, this is what I think, how close in space everyone is. So, for example, if Officer Noonan is here, you just heard him testify that he was 15 feet away by all said and done when Kelsey had the gun pointing at him, so therefore he couldn't grab it. Well, the judge is going to get to be in that bedroom and decide for himself whether or not that feels like that's what happened. He can evaluate all the evidence that he heard. I suspect we are going to hear from the defense, and I suspect Kelsey will take the stand, although you never know. But she may take the stand here, and to say, what she believes happened, and to give the judge something to think about. But not clear. Nobody has said anything. I have no insider knowledge. But I do think that, she certainly may have something to say. It is a bench trial, so, the defense strategy could exclude that if they think the Commonwealth hasn't met their burden. Although I do think that the Commonwealth has been able to show that, at least by all accounts, Officer Noonan's testimony does say that she pointed the gun right at him and tried to murder him. So that's a pretty big statement. And although we may have some issues with the way he testified, a couple of things here and there, whether or not he worked on a detail when he's not supposed to be working, whether he wasn't drug tested. I mean, those are not necessarily things that are his fault per se. But anyway. Okay, so now we are going into day 3 tomorrow. And I think my guess is the testimony will wrap up tomorrow. I'm not 100% sure. And then maybe the view will be on Thursday, and then closings. Closings will be after the view. So we have a couple days maybe to get through the rest of this case. It's coming quick. They're putting on a very, quick, efficient trial here for this judge. It's a lot faster when you have a judge and not a jury, because the judge doesn't necessarily have to take as many breaks. He knows the drill. He's there for all business. Meanwhile, if it's a jury, they take lots of breaks. They want to make sure the jury's taken care of. They get their drinks. They go to the bathroom, all those things. They're not professionally trained to be in a courtroom all day. So it's just a very different situation when you're dealing with jury only. All right. So if you are following the case, if you could be so kind and see if I am asking, I guess I should say, gosh, it gets hard to ask for these things sometimes. But if you would like and subscribe, if you like what you see, we are working to get better at this and striving at becoming professional YouTubers and working on my technical skills, which, by the way, is also really good for the courtroom. It's been very helpful. So needless to say, we'll see you tomorrow for day 3. Like and subscribe. Thanks.